Hello, everyone. Good evening. Assalamu alaikum. And welcome to this webinar on this very important topic of good faith in construction contracts in Egypt. What does it mean? We are privileged to be broadcasting this live from the Cairo Regional Centre, International Commercial Arbitration. And I am privileged to have with me as a speaker, Dr. Engy Serag, to discuss this very important topic. We'll start first with the introductions. And she is someone definitely who does not need any introduction. Dr. Engy Serag has a PhD from University of Central Florida in civil engineering. She is known as the Executive Director in Contracts and Claims in Ascom Construction. She's an adjunct faculty in the Construction Engineering Department at the American University in Cairo. And she is currently finalizing the Executive Masters of Law in the London School of Economics. She's a member of CIArb Egypt, and she's a registered arbitrator in the Egyptian Ministry of Justice and in the Cairo Regional Centre. She's a member in Industrial Advisory Board of AUC, and she has several publications in construction management and claims.
Thank you so much, Walid, for this very lengthy introduction. It's definitely a privilege to be here in Sarsika and being live with you for sure in conducting this very important webinar about good faith and fair dealing. And I will have the honor to introduce my colleague, Dr. Walid Nimr. Dr. Walid is definitely a very well-known academic and practitioner in the area of contracts and claims. He has a PhD from the University of Salford and an LLM from Robert Gurdon University. He is the contracts director of Hill International Africa. He's adjunct assistant professor at the American University in Cairo. He is the vice president of education and training officer in CIArb Egypt. He was the past president and currently the vice president of AACE International Greater Cairo section. He's the country representative for the Dispute Resolution Board Foundation, the DRBF. He's an arbitrator, an expert, a dispute adjudication board member, and his publication on construction claims are very important to all of us.
Thank you very much, Engy. In the ad to this event, Engy, you mentioned that the good faith is a mandatory provision in the Egyptian Civil Code. And I believe you were referring to Article 148 of the Egyptian Civil Code. Now, let's see what this article is saying. It says basically that the contract must be performed in accordance with its contents and in compliance with the requirements of good faith. Notice here the word must, يجب تنفيذ العقد. So actually, it's not really an optional thing. It's a mandatory thing. But then let's look at if you look at the second paragraph. It's not good faith is not just enough. There's other provisions, namely the law, usage, العرف, equity, العدالة, that also run alongside the contract as a sequel to the contract. So that's really a very significant legal provision around which this webinar is based. Now, do you think, Dr. Engy, that there are also good faith provisions in the MENA civil codes?
I'd assume that. Usually civil law jurisdictions have similarities, so I would assume, but to what extent?
Well, it's a long list. Are you ready for that?
Sure.
Okay. So we have good faith provisions in the Algerian Civil Code, in the Bahraini Civil Code, Kuwaiti Civil Code, Libyan Civil Code, Qatari Civil Code, list goes on, Syrian Civil Code, Jordanian Civil Code, UAE Civil Code, the Moroccan Code of Obligations and Contracts, Lebanese Code of Obligations and Contracts, and also the Tunisian Code of Obligations and Contracts.
That's quite interesting. You know that good faith provision is very much popular as well, and it's present in international civil law jurisdiction. Do you want to know?
Please.
All right, let me take you to that. It's present in the German Civil Code, in the French Civil Code, in the Italian Civil Code, and in the PECL, Okay, and in the principle of European contract law, in the UNIDROIT principle as well, which is the principles of international commercial contract. So it's common.
That's quite interesting. And now, before we go any further, we would like to have a poll. So just to know, ask you a few questions before we go further. So the first question is, please indicate your profession. Are you a contractor, an employer, engineer, lawyer, or other? So just take a minute and we'll resume our session once you answer the questions.
Well, that's very interesting. There are a lot of contractors on that webinar, and I can see more as well. So more engineers, that's very good. So there's some sort of equality between the contractor and engineer.
Yes, yes, exactly. Yes.
Some employers are there as well. So thank you for attending, Mr. Employers.
Yes.
Question number 2. Did you come across a solid definition of the term good faith? So let's take a minute for that as well.
Well, Engy, I think it's pretty much what we expected. 64% have answered that they have not come across a solid definition of good faith. Maybe this is why we're also having this webinar. But what's surprising is that 36%, actually, it's more than I thought, they have come across a solid definition of the term good faith.
That's quite interesting. We'll have a very interactive session then.
That's right. The third and last question is basically, were you involved in any situation in a construction context where you felt that the principle of good faith was violated? So you've encountered a situation where you just felt that this was contrary to good faith in construction.
Wow, it's very interesting. 72% of the audience have experienced that violation, and 28% have not. That seems to be their good faith violation is present, or there is some sort of a misunderstanding of the term. So yes. Let's go.
Okay. So let me ask you, Engy, this question. Do you think there's good faith requirement in FIDIC contracts?
That's quite interesting. I think before the FIDIC 2017, there was not any expression. But I think in FIDIC 2017, it was very clear in the early warning clause in 8.4. So.
The early warning clause. So you're talking about this clause, right?
Yeah, exactly.
Okay, so actually, I fully agree with you. Look at this advanced warning clause. It requires each party, the contractor and the employer, to advise the other and the engineer. So actually those two parties will advise each other and the engineer, and also the engineer has a reciprocal obligation of advising those parties as well. Advise of what exactly? Advising of any known or probable future events or circumstances which may, if you look at the four factors below, basically anything that adversely affects the price of the contract, the time of the contract, the contractor's personnel. So basically, I agree with Dr. Engy, is that this exemplifies or signifies how good faith is really how FIDIC actually now has incorporated good faith as part of as a contractual requirement. So not only if you're operating in Egypt or any of the civil law jurisdictions that we've mentioned, not only is it a legal requirement, but it's also a contractual requirement if you're using the FIDIC 2017 contracts.
I remember the ad, Walid, you mentioned good faith, but what does good faith really mean?
I think, that's the $1,000,000 question, actually. So I think, what does it really mean? I don't think there's any defined definition, although I know that a lot of people have been trying to really come to grips with what good faith really means. I brought with me a book, actually. This is called حسن النية في إبرام العقود, and that book, as you can see, it's a pretty lengthy book. It's by Dr. Shirzad Aziz Suleiman, and the book actually goes into the historical origins of good faith, that discusses good faith from a common law perspective, and civil law perspective, Islamic law perspective, even international contracts perspective, UNIDROIT, and so on and so forth. So, but that's good faith in a global sense. Recently, there have been also the literature trying to describe good faith and what it means in a construction context. For example, we have this article in the New York Dispute Resolution Lawyer, which is published in spring 2020, which included an article by Dr. Muhammad Salah Abdul Wahab, which actually is entitled Reflections on the Principle of Good Faith, Variance, Derivatives, and Related Issues in the MENA region jurisdiction. So actually, this is very specific. This is construction, and this is also MENA region. And what's significant about this article, going back to your question, Engy, is that Dr. Muhammad actually quotes 15 examples and variants of what may constitute, what does good faith, what good faith is constituted of. So now, if you were expecting a lecture, this is really where the lecture ends. From now on, it's an interactive session. So what we're going to do is we're going to present some scenarios from construction, and we will discuss them, and we want also your active engagement in these scenarios. So for the remainder of this webinar, what we will do is, first of all, I will present a scenario, and then Dr. Engy will present a scenario, and we have in store for you 7 scenarios in construction, and then we will comment on it. So the presenter will present, and then the other person will comment on it, and then we'll open the floor for you to give us your thoughts. We will just, for the sake of time, we may choose 1 or 2 or 3 volunteers or from the attendees to contribute. Just bear in mind, you can contribute in 2 ways. The first one is you can raise your hand, and you'll be called on. And of course, just bear in mind, if that happens, that you're to keep your mic on and your camera on, so that we can see you as you're presenting your question. The second option is, if you see the Q&A session, the Q&A sign, so you can post your question there, and we will read the question and answer it from there. Very good. And then we will wrap up, basically after the comments that are received, we'll wrap up that scenario and go to the next scenario.
Just minor thing, Dr. Walid, very important disclaimer. The views presented in each scenario are based purely on simple facts. As you will see, these views are definitely subject to change based on the actual facts of the circumstances of a particular case, and definitely the country conditions. So let's go.
Okay, thank you, Dr. Engy. So You ready for the first scenario?
Let's go and
Okay.
share with the audience.
All right. Okay. So the first scenario really is a scenario that is in the tendering stage, one that I encounter very, very frequently. So let's say this. Say that there is a contractor who submits a proposal with no reservations or exclusions. So here I am talking about specifically contractual exclusions or qualifications. Okay, so the proposal submits the contractor submits this proposal, and the other tenders have submitted proposals, and they do have qualifications or exclusions. Okay, so and because this contractor was apparently compliant in front of the owner's eyes with the requirements by not submitting, qualifications and so on and so forth, the owner decides to award the contract to this contractor. Now, after this letter of award stage, as we know, we have a stage where we will negotiate the contract to be signed. So now the contractor breaks his silence and now presents the employer with 25 exclusions and qualifications, comments on the conditions of contract that were not presented before. So in effect, from my perspective, Dr. Engy, this contractor really put the employer in against the wall, put him in a corner, because one of the factors that led the employer to choose this contractor is because the contractor was fully compliant. He did not have any exclusions or qualifications, but now all of a sudden he has a lot of reservations. So I would think that this is could be not an act of good faith, because now the employer is cornered. What do you think, Dr. Engy?
That's quite interesting. Antli, I don't want to be a pro-contractor, but there could be several situations that can lead to that exclusion. Let's, for example, take an example. For instance, he got awarded the project, but the execution happened maybe a year after the award. Eventually, out of good faith, the contractor wanted to come clear to the employer and show him the exclusion, for instance, increase in prices. His base price for his tender is not valid anymore to account for escalation per se. So this could be a very important exclusion. Another thing as well, the COVID, which we have all experienced prior the COVID, if the letter of award was prior the COVID and then the award will happen during the COVID, the contractor has to come clear as well in showing that there are going to be problems in the execution, in the productivity of his labor, in the time for completion. So out of good faith, he listed his exclusion instead of submitting claims during the project. So I would say that this is a very good faith contractor.
Okay, so I see what you're saying. You're saying that there's changed circumstances and that can really justify this kind of action. Okay, so now that really we would like to know your opinion. If you can please raise your hand, or you can type your question in the Q&A box.
I can see some hands are raised, Dr. Walid. A lot of hands are coming there.
Really? I don't see any.
Let's see. We can start. The first one in my list is Mr. Salah Fikri, or Engineer Salah Fikri. If you definitely would love to know your viewpoint on that.
Hello, my voice is clear now?
Yes, we can hear you. Yes.
Yes, I believe it's not good faith because the contractor, he submitted his offer and the letter of award submitted by the owner, it's meaning acceptance. So the contract now, it's already initiated because there is offer and acceptance. So after that, the contractor, he come to try to his new letter with 25 concerns. This meaning he tried to cancel or he tried to breach the current contract. So it's totally bad faith from my point of view.
Okay, thank you, Mr. Salah. We have any other raised hands?
I can see some comments on the chat. There is no good faith, Mr. Mohammed Al-Banna. There is no good faith from the contractor side as he waited to the award to present his exclusion. That's definitely very valid. Let's see, another person, Mr. Fi'i, he's agreeing with me. Thank you, Mr. Fi'i. Definitely depending on the circumstances and the conditions of the contract. So we have it's one of a good faith action because of the early wording. So
I think also Mr. Karim Shawi raises an interesting point. He mentions, what if there's no change in the circumstances? So yeah, I think that's a key point. If there's no change in the circumstances, from my perspective, at least even from my experience, the employer is really in a corner, because as you can imagine, Dr. Engy, this employer went to the board, he got the approval for a certain budget, and then all of a sudden now he has a different set of requirements, exclusions that may affect the price of the contract. So thank you all for contributing. You raised very valid points. I think the core thing really here is transparency in the form of good faith. So if the contractor has any like reservations, these should be shared from the beginning of the project, from the beginning of the tender process. I mean, with the proposal, the fact that contractors submit a lot of qualifications in the tender, in my opinion, that's not a bad thing. Actually, that's a sign of transparency. And also, on the other hand, as Dr. Engy pointed out, owners should be open to changed circumstances. So if we have something, if COVID comes in the middle of the tender process, or the time for signing the contract is unreasonably long, then the owner, also the employer, should be flexible enough to allow for the contractor to provide any concerns on the contract conditions, because this might change. Is there anything else you would like to add, Dr. Engy?
I think you got it. We have a lot of questions. I wish we can answer more. But let's go to scenario number 2, and definitely we will try to answer your questions separately and send it to you separately.
Okay.
Let's go to question number 2. It's somehow related to the tender. The tender documents for a project, as you know, most of the tender document include list of suppliers and manufacturer for several items to be procured. For one of the items, for each item to be procured, there were two suppliers, just for the employer to have some sort of a competitive pricing between those suppliers. For one of the items that has 2 suppliers, one of the supplier does not manufacture such item anymore. So the contractor proposed another supplier and included him in the price, not only the name, the price, and the name and the price in the tender. And he based his price on his choice. The contractor signed the letter of acceptance without any reservations. During the execution, the engineer realized that there's a change. There was an alternative supplier provided by the contractor, and he signed his letter of acceptance without any reservation. He said, this is bad faith. You are not allowed to go for your chosen alternative supplier. You have to go for one of the items, the suppliers listed in my tender document. This is bad faith, and you will not be allowed to use that supplier, which you base your price upon. What do you think, Dr. Walid? Is this bad faith from the contractor?
Well, I just have one question in mind, because you mentioned that the contractor proposed another supplier and included that supplier's price in the tender. But what did the contractor, so I understand from this that the contractor did not notify the employer that there will be this deviation. He just included it in the tender, but did not notify. And maybe this is what caused this problem, because the engineer, when during the contract he received this alternative, he was maybe caught by the element of surprise. Maybe if he had been notified. I mean, this is my only comment.
I agree, Dr. Walid. He could have notified him, but maybe he just thought that just putting it on the documents will be enough. And for sure, the engineer will review each and every single line in his price. So probably it was an oversight by the engineer at the time of the award, and the engineer relied completely on the without reservation. So let's see what the audience thinks.
Yeah. So what do you guys think?
Let's see some raised hands. When it's just Dr. Walid.
Chris?
I think Chris got disconnected.
Okay. Then.
Is it clear now?
Yes, we can hear you, yes.
Okay, hi guys. Well, I think it's not that clear on the proposal, on his list, clarification list or something. I think that, and it was written somewhere in the BOQ or something, it would be the event of default of the employer himself or the engineer who's working with the employer at the time of the evaluating of the tender. And by such time, it's not that clear at all in the documents. I don't think that we would go with the contractor for this price. On the other hand, if you have written it somewhere and it was clear and it was the mistake of the employer of not noticing it, I think that he should have a space of negotiation if this alternative is matching, and the engineer shall study this alternative from now on in the project, and if it's okay and it's providing and in complying of the technical requirements, he should agree on it. And I think it can go for both sides based on the presentation of such a name of the supplier or the manufacturers in the documents.
That's an amazing answer, Chris. I wish you are my engineer in all of the projects.
Thank you.
So very good, actually. It's just the cooperation which me and Dr. Walid were discussing, that they can come up in the middle ground if it's going to benefit the project. So that's definitely a very good action to be taken. Yeah, do you want to take another one, Dr. Walid?
Yes, why don't we try Mr. Maher al-Sharawi? I think
we've lost Mr. Meher.
Okay, then Abdullah
Akpinar.
Mr. Meher, mic is muted.
Mr. Meher is muted. Okay. Okay, can we take another?
Okay, we can look at the.
We can look at the chats and see some. Yes. Oh, here. Is he back? Okay,
go
ahead. Let's take some of the chats. For instance, Ms. Sara Wahba saying, I think the contractor shall abide with the engineer requirements to stick to the vendor list or try to convince him that such supplier would meet the same criteria, which is definitely a very good solution, Ms. Sara. Another one?
Yes, and also... yes?
This is Abdullah Akpinar. I'm sorry, maybe you couldn't catch my voice before. If I'm allowed to continue for the scenario number 2, I have to add my comments if I'm allowed to do so.
Please go ahead.
Yes, please go ahead.
Okay, first of all, greetings from Istanbul, Turkey. Congratulations for this wonderful event. Actually, I will be sharing this.
It seems we have a technical problem with Mr. Abdullah.
Yes, we can't hear you, Mr. Abdullah. Well, if we go to Mr. Ahmed Fuad.
Their offer. Can you hear me?
Now we can hear you. Yes.
Okay, thank you. So. It seems that I am losing you. I don't know. Can you hear me right now?
Yes, we can hear you now. Yes, go ahead.
Okay, so since the contractor has put clarification in his tender, and they have proposed another supplier, since one of the approved suppliers does not manufacturing the item, I do believe that for the benefit of the project, both employer and the contractor should agree on, let's say, common grounds to accept another supplier. So maybe the contractor signed the letter of acceptance with an oversight without putting any reservation, but for the benefit of the project, and the good faith applies for both, I mean, both the employer and the contractor. So I do believe that there has to be a sort of negotiation between two parties, and eventually the project will win.
Well, actually, Mr. Abdullah, you mentioned something that is, I think, a golden words, which is for the benefit of the project. So actually, I fully agree with you. I think that the contractor and the tender and the engineer should really think of the project itself. One thing that caught my attention in Dr. Engy's description is that she said that one of the suppliers of an item does not manufacture. So actually, if you think about that, the error could really be from the designer who specified this supplier who does not manufacture. So the contractor actually, in good faith and being proactive, went ahead and had another supplier had a solution, basically. So that's a sign of good faith. However, what we're saying is to eliminate this element of surprise from the engineer and cause this problem, the contractor should maybe, although it's in the tender, it's in the proposal, but the contractor should have really highlighted this, as you're saying, clearly from the start. And this transparency, I think, like you said, for the best interest of the project, the engineer, the employer has to be more flexible, and the contractor has to be more forthcoming with the notification, so that there's we eliminate any disagreements. Now we'll go to the third scenario.
One more point, please, Dr. Walid.
Yes.
Actually, we are now in the international projects. We are seeing some bidder conference. Actually, this there could be an argument from the let's say employer side that why the contractor did not, let's say, argue this point at the time of bidder conference. I don't know whether the bidder conference is happened for this project or not. If that would be the case, so there could be an argument from the employer side that the contractor should notify this issue before submitting his bid, and if the employer is silent on the issue, then they can put, and they have the right to put, a clarification in their tender. Thanks for this opportunity.
I agree, Mr. Abdullah. It's definitely, there are usually some questions and answers before the submission of the price, and the contractor should have submitted that question indeed for the employer. And if he got no answer, then he should have this exclusion. Yes. But I agree with you, whether in the pre-conference or the conference before the submission, or in the meeting or via a letter, would have been very beneficial to solve that problem.
Yes. So now we come to a scenario that's very close to my heart a bit also. They're all close to my heart, but actually this one is, again, has to do with tendering and construction. And so let's say that the tenderer is aware of a major design omission. So there's a major design defect in the tender documents, but the contractor intentionally, and I underline the word intentionally, does not alert the employer or the engineer. So this tender does not raise the question to say that, this item is omitted from the drawings or is omitted from the BOQ, and just lays low and submits the price, and the contractor is awarded the contract. But then after being awarded the contract, the contractor raises a request for information or an RFI querying about this design omission, and of course requesting a variation. And because it's a major design omission, this might take one variation or a series of variations to cover this omission in the design. Now, and of course, what happens when you issue all these variations, then there's a major cost overrun borne by the employer, and that's because of something that the contractor could have notified during the tender stage. Now, one offshoot of this, example of this, is what we call the missing BOQ items, and that's something like in say if we're in a remeasured or a unit price contract, where the drawings and the specifications have clearly say a certain element of the design, but the BOQ does not have this element. And this is something that is very apparent, it's a major issue, but then the contractor chooses not to notify the employer and ask the question so that an addendum can be issued and a corrective actions would be taken. And this, of course, causes a cost overrun on something that was present in the tender documents. So understandably, the engineer or the employer feels very frustrated for this cost overrun. So I don't know about you, Engy, but I feel that this is really could be a sign of bad faith, because the contractor intentionally, the contractor has a duty to seek clarification during the tender stage, and the contractor here intentionally chose to be silent, and that silence resulted in this cost overrun. What do you think about that?
That's quite interesting, because I'm working for a contracting firm, and it's a remeasured contract you mentioned, right? So
right.
The quantities are definitely the risk of Mr. Employer. So I will leave the word intention on the side, because it's very hard to prove the intention of the party without any written documentation or anything. For sure, we try for a remeasured contract. The drawings are important, but the takeoff is not as important as a lump sum project. So out of good faith, I would just see that the contractor was not sure, because you don't really know about the emissions or the mindset of the employer. So I don't see that as a bad faith, actually, since the employer going in a remeasured contract should know the risk of the quantities. So let's take some opinion from the audience. What do you think?
Absolutely. What do you guys think?
We have some raised hands.
Okay.
My engineer Chris is there, but let me take another engineer. I will just go for Mr. Wael Azizuddin. I think he's coming on the line.
You can hear me?
We can hear you very well, Mr. Wael.
Yes.
Thank you so much for this webinar. It's really a great pleasure and honor to be in such webinars. For my point of view, there is always, let us say, a mix of responsibility regarding the contractor responsibility and the owner and the designer. When Mr. Walid is highlighting that it is a major design omission and while tendering stage, that means it is not related to contractor responsibility, as a contractor in this situation is professional in executing the project, not in the designing. So from the beginning, it is not related to the contractor. This is as per my point of view. For the contract type that it is remeasurable, maybe the contractor is using his rights, how he administrate and manage his contract with the owner.
That's quite interesting. I fully agree with you.
Thank you so much.
That's for your answer.
Thank you. Mr. Abdullah Al-Gindi.
Maybe we're having a connection problem. We can go for Mr. Haytham Mukhtar.
Dr. Walid, can you hear me?
Yes, we can hear you, yes.
Well, thanks, Dr. Walid. Thanks, Engy, for this nice webinar. I herein fully agree with Engy that this is not a breach of good faith from the contractor side. As number one, we assume that this is a design issue, and we assume that this is not a design and build contract. So in the first place, liability is on the engineer's side. And I agree with Engy that who said that this intentional misleading of the contractor was proved. it's totally vague and very hard to substantiate. But what my point is that in most cases, the contractor shall always have the right to issue RFIs regarding increasing quantities, omitted designs, or whatever, as long as it's not a design and build, and in most of the cases, a remeasured contract. Thanks again.
Thank you.
And Dr. Walid, I believe that you come from an employer's background.
Yes, for sure. Yes.
And it's obvious I'm coming from the other side of the contractor, yes. But we're trying really here to be unbiased.
But I hope that you come from an employer's fair point of view.
I try to be. I try to be.
Keep trying.
Thank you very much. Also, actually, from the chats, we have Sarah Wahba mentions that I believe that the omissions are not in the favor of the contractor. Accordingly, if the contractor was aware with such omissions, he will definitely notify the employer earlier to avoid losses. Please clarify the situation. I think this is really one of the of course, we're saying that of course the contractor in a construction contract is not responsible for design. However, what we're talking about is if the contractor was aware. So if the contractor as a experienced professional was aware of something and he had the option to ask the question, should he have asked the question or not? We're not saying he assumes liability or not. So this is maybe this is something that is being highlighted here. And of course, we have to be good faith mandates that we are reasonable. So neither the employer should bear losses that could have been prevented. As actually Sarah, as Sarah mentions, if the contractor would notify earlier, then this could avoid losses. This is the key thing. That's an act of good faith actually on the part of the contractor, and which I believe the advance warning would play a part here. And on the other hand, the employer also should not. The contractor is here to make a profit. So, and this is, as you mentioned, it's a remeasured contract, and this is in the first place. This could be a design issue. So the employer should take also some responsibility. So maybe a middle ground solution would be in call here. What do you think, Dr. Engy?
I fully agree, but there's a very interesting question that me and you, Dr. Walid, were thinking of Mr. Muhammad Aimer was talking about, does the Egyptian Civil Code require good faith in the pre-contract negotiation stages in the case with the French Civil Code reform in 2016? So that's quite interesting, Mr. Aimer, because good faith is present in the code, but definitely it's very important to show the good faith in the negotiation stage, in the pre-contract stage, which I personally have experienced in cases under the civil code. And to show good faith is that you show some sort of evidence that you were, for instance, if you were going in a project, that you were serious about this project. If, for instance, that you're asking for some sort of damages when the contract is not when the tender is not going to go through, that should plus some opportunity. So definitely the good faith should be present in all of the stages of the contract. The Civil Code is just talking about good faith in general, right?
Yes, I believe that good faith is an overarching principle, actually, that goes in all, as Dr. Engy mentioned, and all covers all stages of the contract. Now, shall we take the next scenario?
Yes. That's the one that's very close to my heart, Dr. Walid, the time bars.
Close to all of our hearts.
Okay, if you can just proceed to that one. In a progress meeting, the employer mentioned that consideration is given to issue variation. A contractor verbally alerts the employer that a variation, if instructing, will have a substantial cost and time impact. The variation is instructed. The contractor presents a notice of claim after 45 days. Employer responds that the claim is time barred. The contractor asserts that the employer is fully aware from the progress meeting. What do you think, Dr. Walid? The employer argues that the contractor's silence constituted reconsideration of contractor position and there are no impacts. What do you think?
Well, actually, in this case, I believe that first of all, and of course now going back to the thing of me trying to be a fair employers or an engineer, I would think that fairness dictates, and actually there's a lot of, I think, literature written on the fact that if there is knowledge, so if the employer has knowledge of something, even if it's not in writing, then that knowledge, it would be contrary to good faith, that the employer would actually reverse positions and say that no, it's time barred, because how the employer, the contractor told the employer in a meeting, although verbally, that this is something that is has an impact. Just know that beforehand, and the employer chose to issue the variation anyway. So therefore, the owner has knowledge, and it's contrary to good faith to apply the time bar. And actually, in the 2017 contract, in the claims procedures, I think there is reference in there to in the claims procedures to having knowledge of the claim. So that's one of the differences also between 2017 and 99. However, I think the last point here, that last bullet that Dr. Engy read is significant. When the contractor, there should not be any justification for a contractor to not present formally after receiving the variation, not presenting formally that what the impact is, or presenting the notice, because this silence, as this last point refers, can be understood by the employer to mean that the contractor has, and I would actually add in good faith, the contractor actually has reconsidered the issue and is going to take measures so that there is no time impact, or there's no cost, there's no the impacts are mitigated actually. So that's why when there's no notice, the contractor should have presented the notice, because again, that would put the employer in a corner. Because notice here in your third bullet, you mentioned that the variation is instructed and the contractor completes the variation. So really the employer is maybe put in a corner, I think so.
That's quite interesting. And maybe being the contractor, sometimes it's missed, the notices are missed. And sometimes as well, the contractor is thinking it's a civil code jurisdiction, we're going to rely on good faith. There is an actual damage incurred. So if there's an actual damage incurred, I'm sure if we go to arbitration, the arbitrator is going to rule in the favor of the contractor, because he's actually incur the damages. And there were case precedents in Sersica, actually in the center, that it's indeed not, because the contract has to be performed as it is. As it said, if there is a notice, it has to be serving as a notice. So I think in that specific example, the contractor has to submit his notices provision. He should not rely on good faith, but maybe the knowledge is an important aspect. But I mean, completely relying on good faith is not encouraged. But having the knowledge is definitely something that the engineer should consider. But to prove, if this case goes to arbitration, to prove that he has the knowledge will be a bit hard.
Yes.
Let's see what the audience think.
Yes. So what do you guys think?
I think Mr. Parsons has his hand raised several times. Mr. Andrew Parsons, if you can participate with us in that.
Hello?
Hi, Mr. Parsons.
Can you see me?
We can see you, or we can hear you, yes.
Okay. I'm not sure I can see myself.
Yeah, now we can't see you. So we saw you.
It's okay, go ahead.
So go ahead, Ian.
What do you think of the case?
I had an overall view, really, about because I work in different jurisdictions. So sometimes I, both as arbitrator, sometimes as counsel, there's a conflict between civil jurisdictions and common law jurisdictions. So I get, that's why I've attended this, by the way. This is very interesting topic. Yeah, it's really it's great that you're doing this. But you're talking about civil codes, and that is entrenched in your law. In the common law jurisdiction, I think there is an idea that somehow somebody needs to be fair how they deal with their contract, but it's not entrenched. It's not codified. So that's where I often find that there's a conflict between lawyers and the parties, especially in international contracts. So they have different perspectives about. I'll give you a question for you. What's fair? What's fair? Fairness is a relative concept. So yeah, it's kind of what's fair for one party is not fair for another. And although under dare I say under Napoleonic code, when civil jurisdictions developed under the French jurisdictions, quite right to do that, by the way. I quite like it in a way, that you're trying to say it's actually a fundamental principle that parties should behave fairly. What's wrong with that? As an English lawyer, I think, well, why don't we have that in our law? But we don't. Yeah, so that's all I say. But I come back to the point where fairness is a relative concept. Yeah, I'd love to hear what people think, not just me, but anybody participating. What's fair? What do you think is what's fair? What's not?
Great. Let's see somebody.
Thank you, Ahmed Al-Jariri.
Thank you, Andrew.
Yes, can you hear me?
Yes, we can hear you and we can see you. Yes.
Yes, sorry, I'm outside in the car. Thank you for this interesting lecture. Regarding this scenario, actually, it's interesting scenario, and it's repeated a lot in the construction. Regarding the time bar, actually it's a contractual term, and as per civil law provisions, the contract shall be executed as mentioned in the contract. So as per this provision, yes, we have to apply the time bar provision at the time of executing the contract. Actually, the employer, there is good reasons actually we faced in the projects. Sometimes the employer needs the contractor feedback on this affection, because maybe he will withdraw that. Maybe the time it will not suitable to him, the cost, maybe he cannot afford that cost. So if you tell the Mr. Employer, since as soon as possible, dear employer, this variation may cost X amount and certain time, he will say, okay, no, I don't want. Give me the project as it is. Maybe later on I will do. That will conflict with my visibility for this project. So at the project time, I with the employer to insist on the time barring clauses. If we went to arbitration or the court will apply the justice, will say what the contractor excuses, why he did not submit within 45 days, and what the amount of this variation, if it will make unjust enrichment, or it will affect the profit or make the contractor bankrupt or out of the market. Then, so I believe the court or the arbitral tribunal, they have different way how they handle these cases. But at the project and contract execution time, I'm with the Mr. Employer. I will abide to my contract as my projects need that. Thank you, everybody.
Thank you very much, Mr. Ahmed. You raise a very valid point, and one that actually I raise commonly when discussing time bars. Of course, I think that you agree with me, Dr. Engy, that actually this scenario in itself can merit a whole event by itself, the issue of time bars. There's just one thing I wanted to highlight, and that is the principle of estoppel. So estoppel is known in the in the common law jurisdictions, and not so much in the Egyptian Civil Code and the other MENA region civil codes. But just for your information, estoppel is basically in this scenario, there was a meeting, there was exchange of verbal, you can say, communication between the employer and the contractor. The contractor verbally informed the employer that there will be an impact, and the employer chose to send the variation anyway. So the contractor relied on that he informed the employer, and so the employer knows. So the fact that he sent the variation means that the employer will compensate the contractor. So of course, the contractor's shortcoming is that he did not follow this with a written notification as per the contract, but the contractor did rely on the employer knowing, and therefore if the employer decides to apply the contract time bar, then this will be to the contractor's detriment. The contractor may suffer a loss, and this is really what estoppel is all about. The point that we want to mention here, if estoppel is really in the common law jurisdictions, then it is really a variant of good faith in our jurisdiction, in the civil law jurisdiction. And actually, this point is one of the points that were raised by Dr. Muhammad Salah in the article that we've mentioned. So with that in mind, we can now go to the next scenario. So in the next scenario, let's say that, and this is also one that is very, very, very common. I can't say how many times I've encountered this, and it has to do with the claim detailed particulars. So now we'll move from the notice, and now let's go to the detailed particulars. So the contractor receives an instruction in an RFI, instruction from the engineer, and the contractor perceives this construction to constitute a variation. So the contractor serves the notice within 28 days, informing and complying with the contract, with the time bar provision that, Mr. Engineer, this instruction constitutes a variation. And the contract requires, as you know, that the detailed particulars will be submitted within a certain period from the notice. And as we know, in the FIDIC contracts, for example, there is no time bar for the detailed particulars, but there is for the notice itself. However, the contractor, so by this stage, the contractor submitted the notice. He did not still submit the detailed particulars. However, the contractor went ahead with the variation and completed the work. And then after 3 months from the notice, the contractor submits the detailed particulars, as is common with a lot of contractors. He submits it in a compiled submission that has several other events as well. So this is, let's say, it's commonly like EOT, extension of time number 1 submission, and there's number 2, and there's number 3 after several months. So this submission is rolled with a lot of other impacts, and from it, the employer or the engineer learns that this has this instruction in the RFI results in a 4 months time impact and associated prolongation costs, of course. Now, Dr. Engy, again, I feel that this is again, I would say, contrary to good faith, that the contractor waits for the detailed particulars. It's actually exactly what Mr. Al-Jariri mentioned. But if the contractor had submitted promptly that this RFI instruction will result in a 4 months time attention, then actually what would have happened, and I'm saying this from my experience as an engineer, we would have gone to the employer telling him, look, this instruction has to be, actually wouldn't even have gone to the employer, it would have gone to the designer and said that this is not valid, we withdraw this instruction, for example. So what do you think about this scenario?
That's quite interesting because I face this problem a lot.
Yes.
And let's go backward. This contractor has served his notice. He followed the contract. But for the particulars, there are no damages under the contract in most of the FIDIC contracts per se. So he has not, under the contractually speaking, there are no damages of submitting your particulars at a later period of time. But now, giving the bomb to the employer that there are after finishing the variation, he just give him the time and cost impact. I would see really sometimes this is a good faith from the contractor, and I'm sure some of the employers are just saying, "Who she's pro contractor." It's really because sometimes we're really eager about the project. We want to finish the project on time, whether it's a variation or not. We want to get it finished because remember, having a contractor staying prolonged is another issue of additional cost, additional indirect, and definitely the contractor wants to do more projects. So I would see that as a very, actually a very active contractor who is very eager to finish his project, not just worried about the time and cost. And once this variation is finished, I'm sure the employer knows that each variation would have a cost and time. Nothing is for free, Dr. Walid. So maybe they will argue about the duration and the cost, but for an employer instructing variation and going in this thinking that there will be no cost and time, definitely this is something that I don't think contractually will be entertained if this goes to dispute board or arbitration. So that's my key point.
Okay, so let's see what the attendees think.
Do we want to go with Mr. Ihab Youssef? What do you think, Mr. Ihab?
Hello, can you hear me?
Yes, we can, yes.
In this case,
Mr. Ihab, you're muted, I think.
Now can you hear me?
Yes, we can hear you.
Okay, in this case, I agree with Dr. Engy because as Dr. Walid was saying, the FIDIC has no duration for submitting the particulars, which has some logic to it, because in many cases the contractor is compelled to be delayed in submitting the particulars because actually the 14 days is a very short time to evaluate a variation according to its extent and size. But in most cases, the contractor cannot submit the detailed particulars in this duration. And actually, the employer is issuing a new instruction or a variation in an RFI shows that the employer was trying to give the contractor some additional work inside some document that is not actually for this purpose. If the employer wanted to be clear and have good faith, he would just instruct the variation in a clear instruction. So in this, I totally agree that the contractor was acting in good faith, was acting normally. It is neither in good faith or bad faith. He was acting normally. However, if the employer rejects this, then the employer seems to have had a bad intention from the beginning, trying to execute the variation without giving the contractor what he owes him.
Very good. Thank you so much for this. I think it's a very valid answer.
It's a valid answer, although I have a bit of a reservation. Of course, we do not say that the employer will reject. Of course, that would be completely unreasonable. However, depending on the thing that I think is very critical, especially in the Egyptian Civil Code context, is has harm been caused to the employer as a result of the contractor? Because if you notice, even if there's no bar or time bar there's no consequences on the detailed particulars. However, there is a contract, and the contract has some procedures, and the contractor signed to these procedures. So if by not complying with these procedures, there's harm caused to the employer, then that raises, I would think, a legal issue, and that the employer really has to substantiate this harm, especially that these are procedures in the contract that should be complied with. I just want to mention here, because I see there's a question by Mr. Muhammad Mahdi in the chat. If the contractor's verbal alert, I think this was in relation to the previous scenario, was documented in the meeting minutes, would that be considered a notice even before formally receiving the variation? My opinion is that this can be considered a notice. However, in the FIDIC 2017 contract, bear in mind that the word notice is defined. So actually notice has certain very specific requirements are not in the FIDIC 99. So that's another, I think that would be a
I agree, Dr. Walid, in relation to Mr. Muhammad Mahdi, because I've always been trying to rely on progress meetings, on any letter, not to necessarily saying it's a notice, and just realizing this is my notice. So just to have some sort of, to save myself from the 28 days of the notice. But FIDIC 2017 is quite strict. So I think the notice provision or the word notice have been mentioned more than 50 times in 2017. So there was a lot of burden for the contract administrators administering 2017. So that's quite important to note. So very good. Can we go to scenario number 6?
Yes.
Let's do it. Okay. Such as scenario number 6 is very important. I'm having a lot of cases actually currently that I'm handling, having this scenario. The contractor sends a request for the engineer to take over the work. The engineer refuses to take over the work due to some work still being outstanding. The contractor argues that such items do not impact the intended purpose of the project, and that refusal to take the over is causing unnecessary cost. The engineer is insisting that a taking over certificate will not be issued. And eventually he wants the contractor to be beside him till the last second of the project. So what do you think, Dr. Walid? This contractor has finished and only pending punch items that will not hinder the operation. Shouldn't he give him the takeover certificate?
I absolutely agree that if the items were not affecting the intended use of the project, and I would add, and I'm sure you've experienced this, Dr. Engy, but sometimes even the employer would go further as to actually occupy the project and use the project. In that case, of course, I would think it's not good faith to insist on not issuing the taking over certificate until and of course holding the retention until that time, because that can cause harm to the contractor. But I think that the key question here really, and the debatable question, is the contractor in your scenario argues that such items do not impact the intended purpose of the project. However, there may be a situation where the employer disagrees with that. That says that no, it does impact because I need this part that has to be completed. So basically, in a nutshell, I would agree with you if it is established that these remaining items really do not impact the intended use of the project. Although actually I have to also say that even if they did, there's a procedure in the contract that the engineer can notify the contractor to rectify within a certain period of time. And if the contractor does not, then simply deduct these amounts, but don't hold indefinitely the retention or the issuance of the TOC. So
very good. And actually, just to add, there is a law provision in the Egyptian Civil Code that says if the building is ready for its intended use, then it's deemed to be taken over. So Mr. Contractor can rely on that and just consider himself taken over under the law. So it's a tool that sometimes contractor can use.
Yes.
But let's take what the
Absolutely.
The audience would think. Let's have some viewpoints.
Please share your thoughts. Mr. Mustafa Helmi.
Yeah, we lost Mr. Hilmi.
He's now he's here. Yeah.
Okay.
Yes. Can you hear me now?
Yes, we can hear you. Yes.
I believe this is the point. This scenario is very critical, and I believe the employer resisting to take over the partial the project. It's yeah, from my point of view, it's a pure bad faith situation. Because as the scenario is saying that it's the contractor finished the works for the purpose intended for. I believe the employer can have a partial position, would not affect his contractual position or his liabilities, and also can remove the burdens on the contractor that's being harsh by continuing operating, maintaining, and securing the facilities or the parts that is being finished without being handed over. Maybe it's some kind of that there must be a compromise. This compromise can be for the benefit of both parties. If the employer insists on not handing over or taking over such parts, I believe he's causing damages to the contractor, and this breaches breaks the contractual relationship because the employer is making damages to the contractor. Also, I believe, going back as Dr. Engy was saying to Article 655, if the contractor finished the works and the employer rejected the taking over for not a logical reason, it's deemed to be handed over to him. Thank you.
Thank you, Mr. Mustafa. Do you want to take another one?
Thank you. Actually, we from the chat we have Mr. Hussam Abdul Hayy, who mentions that it is not good faith to reject the issuance of a taking over certificate in scenario 6. The engineer can give a grace period for the contractor to finish the remaining works, then deduct them if not done. So basically, what Mr. Hussam is saying is that really, as we mentioned, there is no justification to really hold this, the TOC. There is another remedial action, which is give the contractor the time, the grace period, as Mr. Hussam mentions, which is actually already in Article Clause 7 in the FIDIC contract. And then if he does not do it, then deduct or have another contractor do it at this contractor's cost. But to hold it indefinitely, that's something that does not really have a solution.
I fully agree. And just to add to Mr. Hassan's question, it's very important that you define the grace period, Mr. Hassan, because the word grace period could have a lot of definition. Is it delaying the application of LDs, or is it an additional time that you can have an extension beyond the original completion date? So definitely, if you're going to have a grace period on your contract or in the memorandum of understanding, your settlement agreement, just make sure that you define a grace period so that you and the engineer and the contractor would have the same understanding.
Thank you, Dr. Engy. We have now come to the, you could say, the final scenario. And really, this is a, before we go there, I just wanted to alert that just as we mentioned in the time bars provision that the estoppel principle applies in the common law jurisdictions, and that, as we mentioned, the estoppel is really a variant of good faith in the civil law jurisdictions. This scenario number 6 can be construed as an abuse of a right or an unlawful exercise of a right under the civil law jurisdiction. In Egypt, this would be Article 5 of the Egyptian Civil Code. And again, as Dr. Muhammad Salah mentioned in his article, that is also, again, a variant of good faith. So that's, again, this is where good faith comes into play, whether it is estoppel, whether it is abuse of a right, all these things would be contrary to the abuse of right would be contrary to good faith, and estoppel would be, it's an equity principle that applies good faith. Now, the seventh, this is the last scenario that we have for tonight, and we've approached actually an hour and a half. We're very pleased with the interactions that we've had in this webinar. Now, this is maybe a bit of a, I would not say it's a bit of a complicated, it's again dear to my heart, but it's a scenario that is a bit complicated, and really we'd like to have some of your views on it. It has to do with delays and liquidated damages. So imagine this scenario that the contractor is in delay. So there's no question that the contractor is in delay and the contract completion date is approaching. Okay, so then the employer issues a variation because the employer knows that the contractor is already in delay, but he issues the variation 15 days before the contract completion date, and this variation takes 30 days to complete. So if you can imagine, this variation is issued. Now the contractor, to complete this variation, it will pass the contractual completion date, okay? But the contractor was delayed in the first place, okay? The employer issues the variation. However, the variation is not issued with any extension of time, okay? So it's just issued, and it practically takes 30 days to complete, extending beyond the contractual completion date. Now, when the work is completed after 2 months, and I mentioned 2 months because, as we mentioned, the contractor was already late, but then he completed the variation and he completed the works that he had to complete, the employer applies liquidated damages because the contractor was late, okay, was in delay. So here the contractor and the employer are arguing. The contractor mentions, as you can see here in this picture, you issued a variation knowing well that it will extend the contractual completion date. So yeah, true, I was late, but you issued a variation that that definitely affected the contractual completion date, and that resulted in a negative float. So although there is a negative float, maybe the negative float due to this variation is less than that of the contractor. However, Mr. Employer, you issued this variation at a very critical time. So this, I would not have completed the project on this time, in part because of this variation. The employer, on the other hand, mentions, you were late anyway, so my variation did not affect the forecast completion date, because if we take the position before I issued the variation, the forecast completion date was not going to be on this contractual date, it's going to be beyond that date. So you can see here that the contractor is referring to the contractual completion date as the base, whereas the employer is referring to the forecast completion date as the base. And this theory, this contractor's argument is what is really called, is based on a negative float theory, and the owners is based on the longest path theory. So the reference points are different. Actually, this point is this scenario is very very crucial, that we dedicated previously a whole webinar on it, and we had it phrased in a form of debate. So my question here to you is the employer's silence about applying LDs at the time of the variation. So the employer issued the variation, did not mention to the contractor at all that LDs will be applied, and that the employer is thinking of the forecast completion date or anything like that. And the employer did not even extend the completion date for the variation. So is the employer's silence about applying LDs at the time of variation a sign of bad faith or not? What do you think, Dr. Engy? And then we can open the floor to...
That's quite interesting. I'll tell you my perspective. And when the contractor is delayed toward the end of the project, definitely he's expected to pay LDs. And when he gets a variation order to end the end, it's like a scapegoat for the contractor. Hey, perfect. I'll just hide my delay on that variation order and I will be relieved. And let's discuss the apportionment of the damages and see who's going to be responsible. Sometimes the employer would come and say, hey, but your delays are far exceeding the variation orders, so you will get LDs. And the contractor, usually there's another counter argument from the contractor and say, once I know that there's a variation order, I started to relax my resources. So I can tell you, a lot of disputes that goes to arbitration happens for that particular period. So your questions about the negative flow theory and the longest path theory and your webinar was amazing. And I think you have a publication about that definitely I encourage everybody to read it. But it's definitely very important to understand those two theories to avoid disputes in construction. So let's take what the audience think.
Yes.
You can follow up on that. Let's run the poll.
Well, actually, this was not in the poll, but this is open for discussion. Mr. Omar Abdul Qadir.
Good evening.
Yes. Good evening.
Can you hear me now, Dr. Walid, Dr. Engy?
We can hear you, yes.
Okay. First of all, I would like to thank you so much for such an amazing webinar. However, in respect of this issue, I do have a point of view here. A part of the longest path theory or the negative float, the cross or naive basis approach in the evaluation of the entitlement, I have another point of view. The employer here is certainly aware that his project will be delayed as a consequence of such variation. And it's apparent that he as an employer is aware that he's not going to benefit from the project at the near future, considering that he is already running further variation or changes in it. Here, in my point of view, since he did not notify the contractor that he is facing issues and he would apply delay damages if the contractor did not complete within the time for completion or because of the contractor delay, I think there is what we call here a default in al-i'dhar, Dr. Walid. He did not give a space for the contractor or a notification for the contractor that he is suffering damage due to the contractor delay. His actions are contradicting this. He's instructing variations, and therefore, as we know in the Egyptian Civil Code, in case the contractor could establish that there is no damage on the part of the employer as a consequence of the delay, and the employer is making variations at such late stage, therefore, I believe it will be an act of bad faith if the employer insisted on applying delay damages while his actions are basically showing that he is not going to benefit from the project at the near future. He is still making variations and he does not notify the contractor with his intention to apply delay damages as a consequence of such a delay. So I believe here that there are two parts. The first one, ركن الإعذار, هو لم يعذر المقاول. And the second one, he's making variation at later stage. Therefore, it's apparent that there is no damages on his part. He's still enhancing his project for a better benefit. So applying delay damages on the contractor or refusing to give him an extension of time and thereafter applying delay damages, I think it's an act of bad faith. And thank you so much.
Thank you, Mr. Omar. Mr. Osama Muntawi.
Hello, good evening, everyone. Can you hear me?
Yes.
Okay.
Fine.
Yeah, in this case, I think the employer doesn't have to give a notification that he's going to apply LDs on the contractor. So in this case, particularly to the direct answer to the question written on the screen right now, no, there is no bad faith. Whether the contractor has caused the damages to the employer or not, it depends on how long was the project delayed due to the contractor's events and how long will it be delayed due to the employer's variation notification or variation instruction. I can give a simple example that if I'm in a power generation project and this project should be completed since 3 months and the contractor is delaying the project, then as an employer, I have a lot of damages to generate power and to sell this power to invest my project. Then since the project is still ongoing and I'm an employer and I have the right to instruct the contractor to do some variations since the TOC has not been issued yet, I ask for a simple variation that takes only 1 week. So extra 1 week of delay does not eliminate the 3 months of delay of the contractor. In all cases, I don't have to give the contractor notification that, okay, you are delayed, I will apply liquidated damages because there is nothing in the contract. In this case, I assume that there is nothing in the contract that obliged the contractor, obliged the employer to give a notification to the contractor that he will apply LDs. And based on the net approach in calculating the entitlement, you will be entitled to additional 1 week of extension of time on the contractual completion date, because at that time you should have been completed the project, and this variation takes only 1 week to complete, and the 3 months remains the 3 months duration remains the contractor's responsibility, and the owner fully entitled to apply liquidated damages. That's my opinion.
That's fair enough, definitely, Mr. Usaima, I think, for the apportionment of the damage at the end and the responsibility of each party. So I fully agree with you.
Actually, I would actually also add that you mentioned net versus gross, and this was another webinar that we also covered because of the debate. One thing I just want to alert Mr. Osama is that in the FIDIC contract, there is an obligation on the contractor, as maybe Mr. Omar mentioned in the law, there is, but also in the FIDIC contract in 99, clause 2.5 obligates the employer to apply, to notify the contractor whenever there's going to be any deduction. Clause 8.7, the liquidated damages, says that it is subject to 2.5. So actually, the employer has to notify the contractor if you're just going with the FIDIC contract. And actually, in 2017, both the even applying damages is subject to clause 20 for the employer, so that he has to notify the contractor. The key issue here is, although I agree that there's this issue of, and as Dr. Engy mentioned, proportionality that can be applied to the liquidated damages. But the point that I'm raising in this question on the screen is that when the employer issues the variation, then the employer should really give the contractor a clue that, you know, you're doing this variation, but I will apply damages. Because, for example, the employer can just simply say, I am looking at the forecast completion date, not the contractual completion date, for example. That's why in the article that Dr. Engy mentioned, one of the recommendations is that if we're going to use the longest path method or even the net method, why don't we just mention it in the contract? So make it very transparent, and this is actually an act of good faith. Make it part of the agreement. We will apply the net method or the forecast completion, the forecast, the longest path theory, for example. So there's no surprises. I mean, this is maybe one thing that is worthy of mentioning. I wanted to also, there is a comment in the chat by, and I'm sorry if I cannot pronounce the name correctly. I think it's Panayotis Vasiliadis. I'm very sorry if I did not pronounce it correctly, but he's saying, if I may, all these are indeed valid viewpoints, but what happens after good faith signs are confirmed? Does that establish breach of good faith without more? And what remedies are available to the contractor under, for example, a well-coded civil code jurisdiction, more so under a common law jurisdiction? It would be very interesting. You need to have a separate webinar around this topic. I think you're saying, what if the signs of good faith are violated? So there's a sign of bad faith. Of course, I think this probably would need a lawyer to answer this question. But I think from my perspective, and I'll also ask Dr. Engy, I would think that if there's a sign of that's contrary to bad faith, that in itself is not lend itself to sort of a punishment. But however, if this bad faith, and as you can see in all these scenarios, there's a consequence that can cause a harm to one of the parties, and this harm will result in, and this is an established principle under the law, that if there's a harm that is caused, that results in compensation. So this is where the link can come, is that if there's a sign of bad faith and that results in harm, then that triggers compensation. So this is And you're right, this is something that, of course, can be another webinar we can discuss. Strange, do you have any comments?
Actually, I was going to read the same comment. It was very quite interesting to me as well. And as we're going to talk again, good faith is a mandatory requirement under the Civil Code. And if the harm is proven and if there is a damage that's proven, definitely good faith will trigger in. The law would fill the gap what's in the contract, and you can claim your damages under the law. So definitely, if you have damages that are because of the breach of bad faith, you can start and trigger that under the law and ask.
Okay, great. We've actually come now to the conclusion of this webinar. We'd like to just conclude with a few very, you can say, very few specific comments. The first thing is that good faith is a mandatory requirement that should not be overlooked. As we have seen in the civil law jurisdiction, in the Egyptian civil law jurisdiction, and actually as you've seen in the long list of MENA region civil code jurisdictions, and as you've seen also in Dr. Engy's presentation of even beyond the MENA region, good faith is not really something to overlook. It's not something to be that should be an oversight. It is a mandatory provision. It's there in the law, so it should be complied with. And in the case of 2017, the FIDIC contract, this advance warning that has now been inside the contract, that should be that's because that we consider that to be a sign of good faith that is now contractual, and we encourage actually that even if we're using the 99, if we're using the 87 edition, why not incorporate this clause into these contracts in the particular conditions, so that as we have mentioned, putting the project first and thinking of the project's interests, that's really where everyone, this is where it's everyone is a winner.
I fully agree with you. Definitely, implementation of the good faith in construction can be a win-win to the project stakeholders. It's the good faith is very important for all of the parties and for the project at the first place.
Yes.
It's important in the negotiation stage. It's important in the execution stage. It's important even in arbitration case. And me and Dr. Reed were discussing even how the good faith could be implemented in arbitration. And maybe we can hold another webinar about good faith in arbitrations. And we have to think about the win-win situation. It's not like good faith and bad faith, two opposite sides, how we can reach a midpoint, like a value engineering recommendation or another alternative design. So it's very important that both parties sit together and have the good faith atmosphere in the project. I know sometimes people are saying it's not utopia in construction, but really partnering together for the benefit of the project is very important, because we're not here to do claims business, neither me or Dr. Walid. It's really our main objective in our position is to minimize the disputes. We want to have a successful project with a minimal cost and definitely not going in disputes.
I fully agree with you, Dr. Engy. And with this note, we would like to thank you all. Actually, we are very pleased with the level of participation. It actually has exceeded our expectations. So we thank you very much for all those who participated, and thank you for being a very attentive audience.
Indeed, thank you so much for attending. It was really an honor and to be with Dr. Walid, and definitely to be with such an audience with such participation level. Thank you so much, and looking forward to seeing you on the next webinar.
Thank you very much.
Thank you.
Take care.